In this installment of Washington Legal Foundation's Legally Brief, Georgetown University law professor John Hasness discusses the erosion of the standard of criminal intent in white-collar criminal enforcement.
Lawyers love Latin. Perhaps that's why they use the term mens rea to describe the simple concept that one should not be subject to punishment unless one has acted in a blameworthy way. Traditionally, the criminal law required a showing of mens rea, which is Latin for a guilty mind, for one to be convicted of a criminal offense. One had to knowingly or at least recklessly act in a morally blameworthy way to be subject to criminal punishment. If you ask a non-lawyer to identify a principle of law, he or she is likely to respond with ignorance of the law is no excuse. For much of our history, this would have been a perfectly sensible response. Traditionally, the purpose of the criminal law was the punishment of those who had wrongfully caused harm to others, not the regulation of interpersonal affairs. One does not need notice of what the law requires to know that one should not intentionally harm one's fellow citizens. The mens rea requirement embodies the fundamental principle that punishment requires personal fault. However, this principle also renders the criminal law a very poor mechanism for economic regulation. Regulation is not concerned with punishing wrongdoing, but with ordering human interaction so as to improve social welfare. To achieve this end, regulation must often prohibit conduct that is not wrongful in itself. When such regulatory offenses are embodied within the criminal law, the assumption that everyone is on notice of what the law requires, that is, that ignorance of the law is no excuse, does not hold. Citizens may commit such regulatory offenses without personal fault, without a guilty mind. To the extent that the mens rea requirement makes it difficult to punish in such cases, it undermines the efficacy of the regulatory scheme, something that suggests that regulation is best enforced administratively through civil sanctions. Unfortunately, at an ever-accelerating rate over the course of the 20th and 21st centuries, federal and state governments have elected to employ the criminal law as a means of achieving regulatory ends. To do so, they've created a myriad of criminal offenses, known as public welfare offenses, that would be virtually unenforceable if the government had to prove that they were committed intentionally. In consequence, Congress and the state legislatures did away with the mens rea requirement for such offenses, allowing the citizens to be convicted of a crime even if their violation was merely inadvertent or was entirely innocent. Further, under what is called the responsible corporate officer doctrine, supervisors may be punished for the inadvertent or innocent violations of their subordinates. This means that citizens can be subjected to sometimes minor, but sometimes significant punishment in the absence of any personal fault. Indeed, citizens have been imprisoned for conduct such as depositing landfill on their own property and importing lobsters in improper containers. It is telling that the Environmental Protection Agency has its own armed enforcement agents. In addition to creating offenses that explicitly dispense with the mens rea requirement, Congress has further eroded the requirement through the creation of offenses that are so broadly defined that citizens can never be sure when they have violated the law. For example, the federal fraud offenses prohibit any scheme or artifice to defraud, something that requires neither an explicit misrepresentation nor that anyone be deceived or suffer any loss. These offenses criminalize virtually any conduct that involves deception or non-disclosure, and has been described by the Second Circuit Court of Appeals as having a virtually limitless reach. Citizens have been prosecuted for claiming that the houses they were selling were good investments, for making perfectly proper patient referrals without informing the patients that they received a fee for doing so, and in Ken Lay's case, for telling Enron employees that he was purchasing Enron stock, which was true, without revealing that he was also making forced sales of Enron stock in response to margin calls. Although the charge against her was ultimately dismissed for lack of evidence, Martha Stewart was indicted and prosecuted for securities fraud. Her offense consisted of publicly declaring her innocence of insider trading, which, in the opinion of prosecutors, was a false statement designed to prop up the price of Martha Stewart living on the media stock. Regardless of what one thinks of Martha Stewart, how many people would know that going on the Barbara Walters show to maintain one's innocence could constitute a federal offense? By passing statutes that criminalize innocent or merely negligent behavior, or that are so broadly defined that citizens cannot be sure when they are violating the law, the federal and state governments have significantly eroded the traditional mens rea requirement for criminal conviction. This is a development to be much regretted. There are many things a liberal government may do to improve social welfare. Government may properly ask individual citizens to make significant sacrifices for the common good. However, there are also many things a liberal government may not do. Visiting the opprobrium and stigma of criminal punishment on those who have not behaved in a blameworthy way is among them. A just legal system does not permit punishment without personal fault. Hence, I suggest that justice demands that we restore the mens rea requirement for